You know, I'm struck in all of this by the comment about the court not wanting to rule on something that's newer than cell phones, the internet. I mean, I think that there's a real issue here. The court is a fundamentally conservative body. They tend to be behind social trends. And it's true, this is a relatively new thing, but support for it is not that new. There was actually a great piece by Nate Silver in the papers today looking at how there's been essentially steady support for gay marriage around the country since 2004. So this isn't a snap thing. And the court usually is behind social trends. And this one's only building.
John Heilman, yesterday, Senator Tester of Montana. Montana came out in favor of same-sex marriage. I mean, the political shifts, and the court is not immune to hearing the politics of this, but the political shifts have been dazzling in the speed with which they've occurred.
Yeah, the train has left the station on this issue, I think, and whether the court, you know, for a lot of people who are in favor of marriage rights for gay people, if the court does decide to strike this case down on the basis of standing, that will be a victory for gay marriage. It will be a victory not just in the state of California, but it will be a victory for the democratic process, because it will essentially say that the court's attitude is, on a state-by-state basis, gay marriage can be instituted. And that's federalism at its best, and states will be open to do that. And given the way the political tides are turning, Senator Tester is a good example, but that's true across the state country, in state after state, many very conservative states. The tide is maybe a little bit slower than in some of the more liberal states, but the tide is all headed in one direction.
And Mark Warner of Virginia.
Mark Warner of Virginia, a lot of southern states, a lot of rural states, a lot of Senator McCaffrey from Missouri. And, you know, Jonathan has pointed out on other shows in this network the fact that for young Republicans that it's now a majority issue. So this is not, as I said, the train has left the station. We will get to the point where 20 years from now, gay marriage will be legal in 50 states. And if the court does go in the moderate direction, as I said, it will be a triumph for marriage rights. And I think, you know, the question is not when. It's not whether anymore, but when this will just simply be a settled matter across the country.
And a victory, striking down Prop 8, having the most populous state in the country having same-sex marriage equality would be huge, because folks will go to California, get married, go back to their home states, and try to apply for all the benefits. The thing that we haven't talked about is the fact that more than 30 states have either a state constitutional ban or a law banning same-sex marriage, and that gets to why Ted Olson and a lot of marriage equality advocates want the Supreme Court to do a sweeping ruling, is so that you wipe away all those bans with one ruling.
And it would be faster to get there that way.
Faster, for sure. Because otherwise, it's going to take decades to unwind all these.
Michael Steele, we get into a lot of trouble when we start reading tea leaves at the Supreme Court, see the Affordable Care Act. But what did you see last night? Do you see any reason that it wouldn't be left to the state?
No, I think this court very much wants to punt this bad boy back to the states as fast as they can get it there. I think that the adjectives that have been set forth already to describe the court's attitude or mindset, I think, are accurate. They are more than hesitant to jump into this. You saw that telltale sign last week from Justice Ruth Bader Ginsburg, who indicated, we made the mistake with Roe versus Wade by acting too soon, not giving the states the chance to actually vet this more fully. And I think that the justices really want to do that. I want to go back to a point that Rana made about the support in the statistics. Support among the population is one thing. Adjudication through the court system is something very different. And I think now with the states, as Jonathan mentioned, 30 states having already adjudicated this either constitutionally or legislatively, when those lawsuits start to come through the system, it'll be very interesting to see how that plays out. And I think that's something the court would rather have happen that way, as opposed to a sweeping, okay, we're going to undo those 30 state legislative decisions or constitutional decisions. And I think the final point is this activity on the ground among the state legislatures is not the same level of activity or support that you see necessarily at the national level. So you can cite all these national figures, all individuals all you want, who are coming around and being, finding themselves involved on the issue. State legislatures are where the action is and where the game is. And as you've already noted, 30 states have said no to same-sex marriage. Now the test is going to be whether or not that tie can change.
You know, I'm really interested in that Ginsburg comment as well, but I really feel that it's not an apples and apples comparison. I mean, when you think about abortion, that's still a hugely contentious issue. There was not this sort of clear trend in the polls heading in one direction, whereas there completely is this time around, and it's an age issue. I mean, you know, as Jonathan and others have pointed out, conservatives, I think it's under the age of 35,
under 18 to 45.
18 to 45 are more likely than older liberals to support this. So it really does just seem like this kind of inexorable vector.
Well, not only that, Michael, but I would submit that the flow of history is so powerful that various state legislatures and the Supreme Court is inevitably going to be up in this. Maureen Dowd is back in the Times today after a long vacation. Her column, Courting Cowardice. I want to read this, just one paragraph in part to you, Michael, get your reaction.
Okay.
It has something to do with what you said. Swing Justice Anthony Kennedy grumbled about uncharted waters, and the fuddy-duddies seem to be looking for excuses not to make a sweeping ruling. Their questions reflected a unanimous craven impulse. How do we get out of this? This court is plenty bold, imposing bad decisions on the country, like anointing W president or allowing unlimited money to flow covertly into campaigns. But given a chance to make a bold decision, putting them on the right and popular side of history, they squirm. And you certainly got that sense from a long line of questioning yesterday that they were squirming, looking for a way to push this away from them.
That's true, but the court is not, and I think Justice Roberts has been very clear about this. He's not looking to put the court on the right or the wrong side of history. He's trying to make the right constitutional decision, which is why the standing issue is a big deal for a lot of these justices, including the very liberal justices who probably are very supportive of gay marriage, but constitutionally know that maybe this party shouldn't be here. They shouldn't be the one bringing this. So, I mean, my only point is that I know while the society is very anxious and hyped up and moving in a general direction, and we see 18 to 40-year-olds really pushing this issue, and they are going to be the outcome determinative voice down the road. Right now, the court is looking at the legislation that's been passed, the laws that have been put in place, and the constitutionality of those laws in the context of whether or not they need to act now. And that is why you see them sort of sitting there going, we don't know yet.